See, today we start with our discussion on fundamental duties. Fundamental duties. Basically, we are going to discuss the nature of fundamental duties, not the duties itself. We are just going to discuss the nature of fundamental duties. See, yesterday there was in the Rajya Sabha, the Citizenship Amendment Bill has been passed. So I'll be giving you a somewhere around 2-page document on it. You will just go through it. It has all the pros and cons about the idea. Though the concerns that are there, though in terms of purely legal sense, if you just go by purely legal sense and as a what the constitution says, etc., you will not find that there are certain, there is almost no concern there. Why? Because if you look at the basic concern is about Article 14 and Article 15 of the Constitution, but we have already seen Article 15 of the Constitution is not available to non-citizens. So 15, 16, 19, 29, 30, if you remember that, we have already seen that it is not available to non-citizens, it is only available to citizens. So Article 15 question that is there, the idea that it is violative of Article 15 does not stand on this ground. Secondly, when we talk about Article 14 of the Constitution, Article 14 of the Constitution basically deals with rule of law. Now, the rule of law, that everyone is below the law. So, in that context, even the Article 14 criteria that is there, it also does not stand here. But if it goes to, if it is appealed in the Supreme Court, and if the Supreme Court declares the law to be unconstitutional, the amendment to be unconstitutional, this amendment will be declared unconstitutional more on humanitarian grounds than on legal ground, because there is no legal ground on it. In terms of legality of it, it is absolutely fine. There is no problem with the legality. There may be a problem with the humanitarian ground, how we consider it on the humanitarian ground, not how we consider it on the legal ground, because legality of this, Article 11 of the Constitution we have already discussed. Article 11 of the Constitution says that the Parliament of India can enact laws to regulate citizenship in India. So power is there with the Parliament. Parliament has passed the law. Secondly, it comes to discussion on fundamental rights, that it is contradictory to fundamental rights. The problem here is that fundamental rights are available to citizens, not to non-citizens. So Article 15 argument does not stand there. Clear? Yes, if you look at it on humanitarian grounds, that because illegal migrants coming from other countries, we have to take that into account, etc., etc. So on that ground it may so stand, but it is purely then on humanitarian grounds, not on legal grounds. Clear? So what are the problems there? What is citizenship by naturalization? I have already discussed those ideas. So you'll get a 2-page document, and that will suffice. According to me, that is going to suffice. Basically, it is an extract of a discussion that I have seen in the Rajya Sabha TV. It was about the citizenship bill itself, and that extract, it was basically an extract of it. It is basically an extract of it, and I added some other concerns as well. Otherwise, it is basically an extract of whatever has been proposed in the Rajya Sabha TV, that discussion that was there. Clear? So, now if you look at the Citizenship Amendment Bill, because we have not discussed it at that length, it may so be that you get a question on it. So prepare citizenship well this year. See, Article 14 of the Constitution says what? Article 14 of the Constitution says two basic ideas. First is the argument that stands here is rule of law. That means when you apply law, you should apply law to everyone equally. Rule of law proposes what? Rule of law proposes that no one is superior to law, everyone is below the law. and this is something that has, this amendment that is there, it is to enact a law. So currently, when it comes to non-citizens, such kind of treatment that is there, the ideas of rule of law, etc., we have come up with this in this manner, that suppose there is a foreigner who is residing on the in the territory of India. So that individual will also be that individual will also have to abide by the rules and laws that are present in India. This is what basically rule of law is about. Because when we come to something called as center-state relationship, you will find that there is a provision there, Article 245 of the Constitution, which talks about what is the jurisdiction of the Parliament in terms of making laws. And you will find it has been mentioned that the Parliament has extraterritorial jurisdiction also. That means laws made by the Parliament is not to be declared invalid just because it has some extraterritorial application. What is meant by extraterritorial application? Suppose an individual, like in this case, an individual is a resident citizen of some other country but is residing in India. So he will have to follow the laws that are made by Parliament. So he cannot claim that because I am not an Indian citizen, so these laws are not applicable for me. Clear? So that is basically what is establishing this idea of rule of law, that yes, everyone is below the law. This argument is in this context, that everyone is below the law. But saying that it is a violation of Article 14 of the Constitution may not necessarily be correct. Now, it may not necessarily be correct, because again, if you go by the sense of equal protection of law, so equal protection of law says what? Equal protection of law says that equals are to be treated equally, unequals can be treated equally. So on that grounds, because the government says that, the government stand is what? That these communities, because they are minorities in our neighboring countries and they have been affected by persecution in those countries. So the argument there is, if the government substantiates it with this manner, that equal protection of law, it is under equal protection of law. So there that will not necessarily have legal grounding, but it is not applicable to Sri Lanka and Myanmar. No, the bill is not for Sri Lanka and Myanmar. The bill is only for 3 countries: Pakistan, Afghanistan, and Bangladesh. So it is not applicable in those. Though they have included Pakistan, Bangladesh, and Afghanistan. So in these cases, if you go by this ground itself, that they are to be declared as in this ground equal protection of law, so it is valid there. Even if they would have extended, because there is an argument also that in terms of Rohingyas, you are treating them as illegal migrants, but they have also faced persecution. Why are you not coming out with laws there? First of all, it is the discretion on the Parliament whether it makes a law on something or not. You cannot force the Parliament to do that. Second of all, even on that grounds, see, there is a problem with that idea as well. The reason is that if you go by a 2014 agreement, basically that it has been considered that there may be some internal security related issues, and because there are security related issues, so we are not going to interfere there. So that that argument is also something that stands. But you can see I have included those arguments in the document. You can see that. Clear? Let's start with fundamental duties. See, I am not going to discuss about the duties, what are the duties that have been mentioned here. We are just going to talk about the nature of fundamental duties. Clear? So write this down. Fundamental duties have been added to our constitution by the 42nd constitutional amendment. Added to our constitution by the 42nd constitutional amendment. Such duties are generally not found. Such duties are generally not found in the constitutions based on Western liberal traditions, they are generally found in socialist constitutions. They are generally found in socialist constitutions to some extent. Their inclusion may also be associated with cultural traditions of a society. Inclusions of duties in constitutions is not found necessary because it can always be imposed by the state. In the absence of consistently with fundamental rights. Their inclusion, however, reminds that the Constitution presents an integrated scheme of which the fundamental or other constitutional rights are only a part of. In a sense, fundamental duties perform an educative role. They also have some legal value. In the sense that any law which implements fundamental duties cannot be invalid on the grounds that it conflicts with fundamental rights until such a conflict is not absolute. It shares the same kind of relationship with fundamental rights as is shared by directive principles. In next paragraph, fundamental duties are not enforceable until unless there is a law prescribing its enforcement. However, it cannot be ignored as it is prefixed with the same word fundamental, under inverted commas, fundamental, which our founding fathers prefixed with terms rights, with the term rights. Hence Hence, the fact remains that it is the duty of every citizen, it is a duty of every citizen to implement and abide by such duties. Abide by such duties. Next paragraph. Though they are not self-executing, but in case of absence of law, non-observance of a duty of one citizen, non-observance of duty by one citizen, if established as violation of right of another, appropriate remedy may be provided by law. Appropriate remedy may be provided by, don't write law, write courts. In brackets write Vishaka versus the state of Rajasthan. So in certain cases you will find that these duties are not enforceable, but in certain cases through a law it can be done. Like if you look at the first duty, to abide by the constitution and to respect its ideal and institutions like the national flag and the national anthem. So if you disrespect it, it can be considered as a violation of law. Like if you look at the court, the Supreme Court is also of the opinion, like there was this idea that whenever you go for a movie, before the movie actually starts, the national anthem plays, and if it is mandated that you stand during the national anthem because it is a sign of respect. The court is of the opinion that if you don't do it, it is punishable. No, it is a punishable offense, despite the fact that there is a liberal idea wherein this is criticized, that you are imposing. But see, the Supreme Court is very clear that if there is a violation, in certain cases, if there is a law prohibiting such a violation, then it becomes enforceable. It is not self-executing, it's not self-enforceable, but if there is a law, it becomes enforceable. So respecting national flag, now there is a law for it. If you disrespect it, it is a punishable offense. So automatically it becomes enforceable. Clear? So this is the nature of fundamental duties. You can get a question on fundamental duties, and it would be in this respect. If you actually go through what you have written, what is the nature of fundamental duties and why it is important, why it is important in governance, as well as what is its relationship with fundamental rights as well as directive principles. So we have dealt with all these ideas in what you have written. That's it. My discussion on fundamental duties is this: you should go through fundamental duties, and you should at least be able to, in your prelims examination, you should at least be able to recognize which of this is a fundamental duty and which is not. Suppose you get a question on it. Now in that case, if you never go through what are fundamental duties, you will never know what are our fundamental duties and what are not. And in that case, UPSC will put up options wherein you get confused and you mark an answer because you will be tempted to mark it. That okay, I have read I have read the constitution, so I'll mark this. And when you mark it, you are very likely to be wrong. So go through fundamental duties. With this, we complete our discussion on part 4A of the constitution, and next we start with part 5 of the constitution, that is union executive. Part 5, which deals with the union And the first topic that we take up here is the office of the president. The office of the president. So who is the president? The president is the highest constitutional dignitary in India. He is the first citizen of India. He ranks first in the warrant of precedence. He is the head of armed forces in India. Under Article 53 of the Constitution, the office of the president is considered to be the executive head of our country. Article 53 says the executive power lies with the president, who shall exercise it in accordance to the Constitution. In accordance to the Constitution. So he may directly or indirectly exercise it. So in accordance to the Constitution. Though the president is considered to be a ceremonial head. Why? Because India is a parliamentary form of government. Because we have adopted for a parliamentary form of government, he is considered to be a ceremonial head, which means he is the head of the state but not the head of the government. He is the head of the state but he is not the head of the government. Constitutionally speaking, the president enjoys two kinds of relationship. One with the Council of Ministers and the other relationship is with the Parliament. His relationship with the Council of Ministers works in this manner that he appoints the Council of Ministers and works on the aid and advice. Of the Council of Ministers. His constitutional relationship with the Parliament works in this manner that though he is not the member of the Parliament, but he is an integral part of the Parliament. So whenever we define Parliament of India consists of the Lok Sabha, the Rajya Sabha and the President. Parliament consists of Lok Sabha, Rajya Sabha and the President. So though he is not the member of the Parliament, but he is an integral part of the Parliament. And he is the one who he is the one who is responsible for, in terms of his function with his constitutional relationship with the Parliament. It works in this manner that he summons both the houses of the Parliament. He prorogues both the houses of the Parliament. He dissolves the Lok Sabha he dissolves the Lok Sabha. Once a bill is passed by the parliament, it goes to the president. The president enjoys some veto powers as well. He has the right to address the parliament. He has the right to address the parliament. Clear? All these he enjoys. So if you look at who is the president, President of India is the ceremonial head of the state. He is the head of the state but not the head of the government. That is the reason why we say he is a ceremonial head. Though he is the first, he is the highest constitutional dignitary, first citizen of India, ranks first in the warrant of precedent, heads the armed forces. He alone can declare war or peace with any country. Article 53 of the Constitution says he is the executive head. Executive powers of the Union lies with the President, who shall exercise such powers in accordance to the Constitution, whether it is directly or indirectly. Because we adopt for a parliamentary system, that is the reason why he only becomes a ceremonial head. He enjoys, constitutionally speaking, two kinds of relationship. One is with the Council of Ministers. So he enjoys a specific relationship with the Council of Ministers. He appoints the Council of Ministers, works on the aid and advice of the Council of Ministers. Even have the right to encourage or warn them. He even has the right to encourage and warn them. Similarly, as his constitutional relationship with the parliament works in this manner, that though he is not the member of the parliament but is an integral part of the parliament, as the parliament consists of the Lok Sabha, Rajya Sabha and the president, he has the right to address both the houses. He summons, prorogues both the houses, dissolves the Lok Sabha. Bills that are passed, it becomes, no, the bills that are passed, they become law only when it receives presidential assent. If he does not directly give his assent to all the bills, he can exercise some veto powers as well. Clear? Now, let's start with our discussion on election of the president. Election of the president. We have already seen in the preamble declares that India is a republic, which means the head of the state in India is an elected office, not an appointed or a hereditary position. So the President of India, keeping in line with the value of republic, the President of India is elected. They are not appointed. They are not appointed. The position is not hereditary in nature. It is an elected office. Now, if you look at the election of the president in India is indirectly elected. Indirectly elected. So how is the president of US elected? Is he directly elected or is he indirectly elected? He is directly elected. Bilkul galat hai. Today we are going to compare. First let's look at the President of India, how President of India is elected, and then we'll compare how President of US is elected. President of India is indirectly elected, and his elections, because we are saying he is indirectly elected, which means his elections is taken up by an electoral college. And this electoral college comprises of what? This electoral college comprises of all the elected members of the Parliament and also the elected members of state legislative assemblies. Elected members of the state legislative assemblies. The term state here, after the 70th constitutional amendment, also includes Delhi and Puducherry. It includes Delhi as well as Puducherry. So we have, as of now, we have two UTs with legislature. Yes, there is a UT of J&K, but right now it has not been formed. But if we look at two UTs with legislature, they are Delhi and Puducherry. And the 70th constitutional amendment, made sure that the term state legislative assemblies. So when we are talking about legislative assemblies, here when we refer to it to state legislative assemblies, we also include the legislative assemblies of Delhi as well as Puducherry. Clear? So this 70th constitutional amendment was taken up in 1992. Underline the term elected here, which means all nominated members are not allowed to vote. Only elected members are allowed to vote. Nominated members are not allowed to vote. So if we talk about the Lok Sabha, so there are some individuals who are actually nominated to the Lok Sabha. Two individuals very specifically, they are nominated to the Lok Sabha. Our country is divided into 543 constituencies. We elect 543 members to the Lok Sabha. Two of them are nominated, which means total 545. Similarly, in the Rajya Sabha, there are 12 members who are nominated. We elect 233 members, 12 members we nominate. The president nominates. In that case, they are not allowed to vote. Similarly, in the state legislative assemblies, all the state legislative assemblies, in the state legislative assemblies, we have one individual who is nominated by the governor of that particular state, who belongs to an Anglo-Indian community. Like in that of Lok Sabha, 2 members, Anglo-Indian community. Similarly, 1 member in each state, there is a provision that the governor can appoint from Anglo-Indian community. That individual is not allowed to vote when it comes to elections of the president. Because state legislative councils, the upper house that is there, it is completely a non-elected body. It's not an elected body. In that case, we do not, it's not a directly elected body. Hence, we do not actually allow them to vote. So, who votes? Members of Lok Sabha and Rajya Sabha, but only elected members of Lok Sabha and Rajya Sabha. Similarly, only elected members of state legislative assemblies. Clear? Understood this idea? Clear? Now, these members that they vote, these members that are there, they vote on the basis of or on the mechanism of something called as single transferable vote and through proportional representation. Through the mechanism of proportional representation. So by means of single transferable vote and through the mechanism of proportional representation. So let's understand what is the meaning of these two terms. Single transferable vote and proportional representation. First, let us look at the term single transferable vote. There are number of offices that we are going to talk about wherein we are going to use the same term, single transferable vote and proportional representation. I am going to discuss this here. I am not going to talk about it every time. Clear? What is the meaning of single transferable vote? Let's understand this. Suppose Suppose there are 4 candidates who are contesting for the election, contesting in the elections of the president. Clear? And the members that members who are allowed to vote, the electoral college that is there, they vote in this fashion. So suppose I am a member of the parliament or the member of MLA, state legislative assembly, and I am voting. In that case, what I will do is I will vote on the basis of my preference, or I have a choice to vote on the basis of my preference, which means I can vote for everyone based on preference. So A is my first preference, suppose, B is my second preference, C is my third preference, and D is my fourth preference. When everyone has voted and when counting starts, so counting that is done there, it is done on the basis of preferences. And the first round of counting that happens, it is based on my first preference. So every individual has voted on the basis of preference. So which individual is my first preference? So when first round of counting is going on, in that case I will, or the concerned body will only count the first preferences. They will only count the first preferences. Suppose it so happens that A gets 40% of the votes, B gets 30% of the votes, C gets 20% of the votes, and D gets 10% of the votes. Clear? Now, if we go by how elections happen to the constituencies, that means in the MLAs or MPs, when we are voting, we vote for only one individual, and whoever gets the highest number of votes is elected as he is the winner. He is declared as the winner, the representative of that constituency. This is not the case when it comes to election to the president, to the office of the president. What happens is, to get elected, an individual requires to secure at least more than 50% of the votes, more than 50% of the value of votes, more than 50% of the value of votes. And if suppose here, if you look at this scenario, no one has more than 50% of the value of votes. An individual has 40, 30, 20, 10. In this case, what are we going to do? See, what is the term? Single transferable vote, which means it's not going to happen that everyone is going to vote again. No. Here what is going to happen? Here I am going to transfer vote. Single, so everyone has voted once. Transferable vote, which means I am going to transfer vote of one individual to the other. How does that happen? The individual who has secured the least amount of votes, in this case it is D. So D is removed from the race. D is removed from the race, and his 10% that he has had, the vote that he has, is distributed among the remaining candidates based on second preference. So whatever is the second preference, that will be distributed. Suppose he gets 4, he gets 3, and he gets again 3%. So that 10% that is there, it is distributed. That 10% that is there, it is distributed. For better understanding, let us look at this. That 10% that is there, it is distributed among 4, 3, ABC in this manner, 4, 3 and 2. So 1% कहाँ चला गया? ये question है ना? In this context, you can understand that as a member of electoral college, I will vote according to my preference. So I might vote for everyone, or I might vote for only one individual. So in this case, suppose some of them, that 1% of the votes that are there, they have voted only for D. They have voted only for D, not for any other candidate. So that will not be counted anymore. Clear? Now see, this individual has 44%, this individual has 33%, and this individual has 22%, which means no one has secured more than 50%. In this case, again what we are going to do? We are going to remove C from the race. We are going to remove C from the race. Now, what are we going to do? Which means, no, when we remove them from the race, what is the objective? To transfer their votes. So, for 20% of the members, C was the first preference. So, their votes, this 20% will be transferred to A and B on the basis of second preference. This was their first preference. So, their second preference, we have not counted their second preference. So, their transfer would be on the basis of second preference. And for this 2%, C was their second preference. So, for them, it will be their third preference. Clear? So, this continues till an individual gets more than 50% of the value of votes. This is what is called as single transferable vote. I will vote once, but my vote is transferable. Why? Because I am voting on the basis of my preferences. If here A on the first round of counting itself, if A gets more than 50%, he is declared as the winner. There is no need for second round of counting. But if no one gets more than 50%, what we are going to do? We are going to take up second round of counting. And we are going to eliminate the individual who has received the least amount of votes. We are going to eliminate that individual. And whatever votes he has, we are going to distribute that vote or transfer their vote in the remaining candidates on the basis of second preference. And this continues till an individual gets the 50% mark. The individual achieves that 50% mark. Clear? This is what is meant by single transferable vote. Understood this? No confusion with respect to how it is working. So, single transferable vote. No, we are going to decide 22%. This on the basis of second preferences and this on the basis of third preference. Because C is no more there in the race. He has been eliminated from the race. Clear? Clear? This is what is single transferable vote. Now, what is then the meaning of proportional representation? Proportional representation means in accordance to the population that you represent. In accordance to the population that you represent. Now, what is the meaning of this? It means that if you give one vote to every member, when I was saying 50%, more than 50%, what is the term that I used? I used the term more than 50% of value of votes, not votes. I said more than 50% of value of votes. What does that mean? Value of votes. It means we are going to distribute the value of votes among MPs and MLAs on the basis of the population that they represent. On the basis of the population that they represent. Which means MLAs and MPs are not going to have same value of votes. Obviously. Agar aisa hota, so what will be the result of it? The result of it is the states, if you look at the state legislatures in the parliament, how many individuals are eligible to vote for the elections of the president? 543 members from the Lok Sabha, hypothetical situation, 543 members from the Lok Sabha, and then there will be 233 members from the Rajya Sabha, which means in total 776 members are voting from the Lok Sabha. And how many members are voting from the state legislative assemblies? UP में ही 400 हैं. There are only 400 in UP. So if you look at other states, include the states of Bihar, then MP, Maharashtra, you will find every state has somewhere around 230, 240. So see, then these states, 400 coming from UP, 200 odd coming from Bihar, 200 odd coming from Maharashtra, 200 odd coming from Karnataka, and they themselves decide who is going to become the president. So that is not the case. What we do is we distribute on the basis of the population that they represent. So 80 members of the Lok Sabha from UP is going to have the same value of votes as 400 members of the Legislative Assembly of UP. Why? Because they are representing the same population. One state, they are electing 400 odd members to the Legislative Assemblies and 80 members to the Lok Sabha. So they are going to have the same value of votes. And how is it decided? It is decided by a formula. What is that formula? You can write this down. Just write, give a subheading here, write value of votes. Value of votes. What is, how do we decide? How do we actually calculate the value of vote of an MLA? It is calculated by this formula. Total population of the state in 1971 census divided by number of elected MLAs into 1 by 1000. Clear? So 1971 census, what was the population in 1971 census? Divided by number of elected MLAs into 1 by 1000. This is how we calculate the value of votes of MLAs. How is the value of vote of MPs calculated? Total value of votes. Total value of votes of all MLAs divided by total number of elected MPs, and what we get is value of vote of 1 MP. If you see this and if you calculate this, if you look at these two, whatever value you get, you will find it is in parity with the population that they represent. In parity with the population that they represent. For those who have not understood, I'm again talking about this. देखो, simple सी कहानी है. How many members get elected from Delhi to the Lok Sabha? 7. How many members do we have in Delhi State Legislative Assembly or Legislative Assembly of Delhi? 70. देखो, the same area from which we elect 7 MPs, from the same area we elect 70 MLAs. So if we give one value of vote to everyone, so MLAs become more powerful in terms of elections to the president. But we cannot do that because MPs are also representing the whole of the country. And that is also when we add all of the MLAs, the population, the proportion should be maintained. So if you look at in this, in crude sense, just understanding in crude sense, one MP is almost representing the 10 MLAs because 7 is to 10 hai, 7 is to 70. So one MP is representing the same amount of population which is being represented by 10 MLAs. So we divide the value of votes in such a manner that the value of vote of 1 MP is almost similar to the value of vote of 10 MLAs. Clear? And this is how we do it. We come up with a formula to do it. And this idea is called as proportional representation. Proportional, the term being proportional. Proportional means what? In proportion to. Representation means in proportion to the people that they, or in proportion to the number of people they are representing. So obviously a constituency of an MP is much larger than the constituency of an MLA. And that is the reason why we come out with a formula so that we take up proper, appropriate distribution of value of votes. Clear? Have you understood this idea? This is what is meant by proportional representation as well as single transferable vote. So how is the president elected? President in India is indirectly elected. And for the election of the president, there is a electoral college that is formed. And this electoral college comprises of what? This electoral college comprises of elected members of the parliament and elected members of the state legislative assemblies. Here, state legislative assembly post the 70th constitutional amendment in 1992. Since then, it has included the term Delhi and Puducherry. After elections to the J&K legislature, and post that you will also find that J&K will also be included. Clear? But this is done through a means of single transferable vote and proportional representation. What is single transferable vote? Every individual votes once or single time, but the manner they vote is based on preferences. And when we calculate the first round of counting is done, we take only the first preferences. And if a particular candidate gets more than 50% of the value of votes, he is declared as the winner. But if no one gets more than 50% of the value of votes, in that case, the individual who has secured the least amount of vote, he is removed from the race, and his vote, his percentage of value of votes is distributed on the remaining candidates based on second preferences. And this continues till we get an individual who has more than 50% of the value of votes. Clear? Proportional representation means, it means on the proportion, the value of vote of one MP or one MLA is calculated on the basis of the proportion of population they represent. And hence we have opted for a formula, and this formula decides what will be the value of vote of one MLA and what will be the value of vote of one MP. Clear? Clear? This is the meaning of single transferable vote and proportional representation. Is it absolutely clear? No, MPs are elected members of the parliament. They are already going to vote. क्या कंफ्यूजन है? नहीं, अगर डबल काउंटिंग में आते तो सारे स्टेट में आएंगे ना, एक में ही थोड़ी ना आएंगे, क्योंकि हर स्टेट में एमपीज वोट कर रहे हैं, हर स्टेट में एमएलएज वोट कर रहे हैं ना. ऐसा थोड़ी ना कि सिर्फ स्टेट लेजिस्लेचर ऑफ दिल्ली और पुडुचेरी वोट कर रहा है, सारे स्टेट लेजिस्लेचर्स वोट कर रहे हैं. हाँ, कोई लॉजिक ऐसा नहीं है. मुझे पता था कि कोई ना कोई मुझसे ये क्वेश्चन ज़रूर पूछेगा. But the idea is not logical. See, there is no logic attached to it. If you look at something called as delimitation, ठीक है, there are certain technical terms. मैं उसमें जाना नहीं चाह रहा था, चलो फिर भी बताता हूँ. Constituency जैसे हम डिसाइड करते हैं, suppose मान लो हमने कॉन्स्टिट्यूएंसी डिसाइड कर लिया 1, 2, 3, 4. ठीक है, 1, 2, 3, 4. These are the constituencies that are decided. What do we do? What is the basis of deciding these constituencies? What is the basis? The basis is population. That means this constituency, this constituency, this constituency, and this constituency has to represent almost similar kind of population. So if this represents, suppose, a population of 1 crore, so this will also represent somewhere around that. Gross mismatch नहीं होना चाहिए कि one constituency represents a population of 1 crore and the other constituency represents a population of 5 lakhs. This gross mismatch should not be there. And that is the reason why we tend to do what? We tend to delimit the constituency from time to time. We are trying to redraw the boundaries. Okay, because of population, to so ensure that there is proper representation, we redraw the boundaries. And currently, the delimitation that we have done, it has been done on the basis of 1971 census. So if you look at the population of, Delhi, population of Delhi is almost somewhere around 5 crores. Almost somewhere around 5 crores. If you look at the population of Arunachal Pradesh, kam hai na? But what we do is we have taken 1971 census to decide what will be the limit of this constituency. And that is the reason why you will find in the northeast there are only somewhere around 25 seats to the Lok Sabha. Why? Despite the fact that there are almost 7 to 8 states there, but we have given only 25 seats in the Lok Sabha. Why? Because in India, the constituencies are dependent upon the population that is there. So when we have taken up delimitation, we find that okay, because of the population of the northeast being less, the population is less, so we have to maintain a certain kind of parity, and that is the reason. That is the reason why 1971, because last delimitation that we have done, in that we have decided that this will be taking 1971 census till when? 2031. Till 2031 we will be continuing with this census. Post 2031, in constitution you are going to read 2026, but the term is this: after the next census after 2026, which is obviously 2031. So after 2031 we are going to again redraw boundaries. So either we'll be taking up two things: either we increase the number of seats in the Lok Sabha, or we redraw the boundaries so that the seats remain the same, but there is proportional representation that is done. If we do not take up a limit, तो क्या होगा? We have to every 2 years, every 3 years, every 5 years we have to delimit, क्योंकि population तो इंडिया में population ऐसा वैसा rise नहीं हो रहा है, ठीक है? So in 1971, if the population of Delhi was suppose 50 lakhs, so today it is somewhere around 3 to 4 crores. So you can understand that. तो हमने, so that it is simplified, हमने एक 1971 census अभी लिया हुआ है, और हमने decide किया है that after 2026 the next census that is done, that census will again be taken into account, and then we will redraw boundaries. उसके बाद 1931 के बाद हम जब delimitation कर लेंगे, after that what we will do? After that we will again decide next, okay, now we have done according to 1931, now we will do it suppose after 20 years or after suppose 30 years. So we'll decide a date, okay, after this census. तो उसी context में हम 1971 census लेते हैं. We try, no, for state legislative assemblies, other kind, the different kind of uniformity is there, and that is also true for Lok Sabha. So if you look at, why is it that in UP we have 80 Lok Sabha constituencies? Because the population of UP is 20 crores. So somehow किसी ना किसी का proportion तो रहना पड़ेगा. So if you look at the constituency, on other hand, you look at the state of J&K, territory wise कितना बड़ा है, but you will still find that there are only 3 or 4 Lok Sabha constituencies there. It used to be 3 or 4 Lok Sabha constituencies. Why? Because it is in proportion to population. So we try and ensure that each and every member of the Lok Sabha that is there, they are representing almost similar kind of population. That is the reason why we actually take up this. Clear? Absolutely clear? This is how the president is elected. Clear? We form an electoral college. From an electoral college, who are the members? These are the members of electoral college. They vote on the basis of single transferable vote and proportional representation. This is how we decide the value of votes, and this is how the president is elected. Clear? Now in next paragraph, write some facts here, very important. Before we come into the election of the president of US, because in your syllabus there is something called as comparison of constitutions of the world. So there are some constitutional offices that are there and we are going to compare them, like president is there, or when we talk about the speaker of the house, etc., etc., we are going to compare them. So certain facts. In presidential elections so far in India, in 1977, Neelam Sanjeeva Reddy was elected unopposed. In 1969, VV Giri was declared elected. VV Giri was declared elected at the end of second round of counting. In all other presidential elections, the winner has been identified after the first round of counting. Clear? So 1969 was the only time when there was the second round of counting. उसमें बहुत interesting कहानी है. Basically what happened was that Indira Gandhi was the prime minister, and Indira Gandhi, I given you this idea of a syndicate that was in existence in Congress party. कभी मैंने बात किया अच्छा नहीं. See, what happened was that if you look at post Jawaharlal Nehru, after Jawaharlal Nehru, Lal Bahadur Shastri was not the political candidate to automatically become the prime minister. He did not enjoy that kind of influence in the Congress party. The second in line was Morarji Desai. He was one of the senior most leaders in Congress and he enjoyed a lot of influence. But Lal Bahadur Shastri became the next prime minister because Lal Bahadur Shastri had the support of a group within the Congress which is called as syndicate. There were some leaders, K. Kamraj, etc., and they were the ones who led the syndicate. So they were not the ones who actually wanted to directly enjoy power. They wanted to enjoy power indirectly. Why? Because they were like kingmakers in the Congress itself. So because of the support that Lal Bahadur Shastri got from the syndicate, he became the prime minister before Morarji Desai. Similarly, when Lal Bahadur Shastri passed away, next in line again was Morarji Desai, not Indira Gandhi. But Indira Gandhi became the prime minister because she was supported by the syndicate. And यही गलती की syndicate ने. When she became the prime minister, after assuming office, she started concentrating powers within herself. Obviously, she did not want to become a prime minister, a puppet prime minister. So she did what? She started concentrating powers. By 1969, she was almost 3 to 4 years in office, and by this time she had concentrated powers. She knew that she had effective control on the Congress as well. So when 1969 presidential elections came, in 1969 the political party, the Congress party, proposed the name of another candidate, and VV Giri was not the candidate of the Congress party. VV Giri was not the candidate of Congress party, but VV Giri got the support of Indira Gandhi, and at the eve of elections, that means tomorrow was elections, and today Indira Gandhi called for a meeting of the Congress party, and though she did not directly say that you should vote for VV Giri, but she said that the members of the Congress party in legislature should vote on the basis of conscience. Which means she she specifically pointed out not on what the political party has to say, vote on the basis of your conscience. With this, VV Giri got the support of lot of members of the Congress party, and there was a split in the Congress. Post the VV Giri winning elections, presidential elections, there was a split in the Congress, leading to Congress I and Congress O. Congress I standing for Congress Indira. So she was the prime minister, but she was, being the prime minister, she was removed from her political party. But the kind of support that she had, obviously, Congress party, Congress I, that was the political party which emerged victorious, and the syndicate was destroyed. The political influence of the syndicate was somehow destroyed. Then later on, there was again, there was like a reunion of Congress I and Congress O, and Indira Gandhi became absolute authority. So this is how she actually broke the syndicate, and it was that was the very reason why VV Giri did not win presidential elections in the first round of counting, because there were two splits in the Congress itself. Two groups that were in existence in the Congress itself. Some of them voted for what Indira Gandhi had to say, and some of them voted for the candidate, the syndicate candidate. I don't remember his name right now. In NCRTs, if you are going through NCRTs, there is an NCRT called as India Since Independence. And if you read that particular NCRT, you will find all about the Congress. Initially, when she was the Prime Minister, initially Indira Gandhi was called as Kagaz Ki Gudiya. She was nicknamed Kagaz Ki Gudiya. Why? Because though she was the Prime Minister, but she did not enjoy the same kind of authority. So she was nicknamed as Kagaz Ki Gudiya. But later on she was known as the Iron Lady. तो वो जो ट्रांसफॉर्मेशन है ना ऑफ इंदिरा गांधी फ्रॉम कागज की गुड़िया टू आयरन लेडी, दैट वाज हाउ शी कंसंट्रेटेड पॉलिटिकल पावर्स. इंदिरा गांधी वाज एन एब्सोल्यूट टोटलिटेरियन लीडर. उनके आगे कोई भी नहीं था. No, she was the one who actually destroyed the Congress. Why? Because she was the one who did not allow any other leader except for the Gandhi family or emerging from the Gandhi family to become the leader. That is the reason why it was only after the death of Indira Gandhi, but there was no leader in Congress. Who was to become the next prime minister when Indira Gandhi died? The automatic choice was Rajiv Gandhi, despite the fact that he was not the member of Lok Sabha, he was not the member of Congress party, nothing. An individual who was not the member of parliament became the prime minister of India. Why? Because there was no leader to substitute Indira Gandhi. So when we talk about centralization of political power, तो उसका absolute example जो है ना, it is Indira Gandhi. It is Indira Gandhi, and that is the reason why the Congress party that you see today, the party which is which has almost no authority at all, the foundation of this Congress was laid by Indira Gandhi. It was led by Indira Gandhi. इसीलिए हम बोलते हैं चापलूसों की पार्टी है. Yes, this is why we say this, because no individual could contradict what Indira Gandhi had to say. And this is the result of centralization of powers. Whenever we talk about political parties, if they centralize power, this is what you get. And BJP has not learned its lesson. You will find that there is too much centralization of powers that is going on. And this centralization of power will lead to, not today, not after 5 years, not after 10 years, but history repeats itself. और ये चीज़ बीजेपी नहीं सीख रही है. If though in terms of if you look at the leaders that they have, yes, they currently have that, but it may not exist if they continue in the same manner. It may not exist after 10 years. It may not exist after 10 years, and then you will find ultimately Rahul Gandhi will become the Prime Minister of India. Ultimately, yes, destiny है उसका. He is destined to be the Prime Minister of India. Not today, not after 5 years, but maybe after 10 years. ठीक है? So this is what happens when centralization of power is there. ठीक है? Next paragraph. After the 11th Constitutional Amendment Act, in 1961, the vacancies in the electoral college of the president, including the dissolution of legislative assembly, is not a valid ground to contest the election results before the Supreme Court. The election results can be challenged only by the electors or the candidates who contest elections. The presidential election is conducted by the Election Commission of India, and the returning officer is the Secretary General of Lok Sabha and Rajya Sabha, taking terms alternatively. Clear? So this is how, and obviously there is something called as these two ideas, that is how this indirect election, electoral college, and these two ideas, that is what is the value of vote. This is mentioned under Article 54 and Article 55 of the Constitution, which talks about election of the president and manner of election of the president. This is Article 54 and Article 55. Then there is also something called as Article 58 of the Constitution, which talks about the qualifications for an individual to become the President of India. What are the qualifications that should be there? But you can go through it. It's not that important. A citizen of India, 35 years of age, qualified to be a member of Lok Sabha, etc., etc. It is there. You can go through it. Clear? Now let's compare the election of the President of India to the election of the President of US. Now, what you said was that the election of the president is directly, the president of US is directly elected. Clear? Now, when we see the last elections, 2016, the last elections that happened of the US president, so who got more seats, more number of votes, Hillary Clinton or Trump, Donald Trump? Hillary Clinton. Clinton got more number of votes. So if they were directly elected, so Hillary Clinton should have been the president of US. But that did not happen. Donald Trump became the president. Why? Because Donald Trump was able to win the Electoral College. What he got, why he became the president of US? Because despite the fact that he was not able to, despite the fact that he was not able to win the largest number of votes, but he was able to win the largest number of seats in the Electoral College, which means there also elections that are going on, the president of US is also indirectly elected. The president is also indirectly elected. There what happens is, there the whole country is divided into, an electoral college. Whole country is divided into an electoral college, which consists of how many members? Their electoral college consists of somewhere around 465 members, 465 odd members, not an exact figure, you can check this, 465 or 435 members, plus 100 plus 3. Now what is this? There are somewhere around 465 members who are there to, who are elected to the House of Representatives there, the lower house. There are 100 members who are elected to the Senate, so 100, that 100 members plus 3. So in total it goes to 568. 568. So what is the, if we divide it by 2, what do we get? Somewhere around this, 284, somewhere around this figure is there. Now there is no need to know the exact figure. I'm just giving you how it is actually done. So there what happens is that there is an electoral college formed. Now there is an electoral college formed, and this electoral college has this many members. So to win the elections, to becoming the president of US, you need to get 284 plus 1, that is somewhere around 285 seats in the electoral college. If you get 285 seats in the electoral college, you win the elections. Somewhere around this particular mark is there. According to me, it is 275, but I'm not very sure. But that's all right. Electoral college, you get these many members somewhere around, you have to score somewhere around 285 seats to actually win the elections. Now see what happens. In every, based on this, this what happens is that an electoral college gets elected, which has somewhere around these many members, and this electoral college that is there, out of these 500 odd members that are there, this 500 members votes for or in favor of which candidate, of which political party, it is decided by the people. This is decided by the people. So how does it work? Figure se samajhte. So this is an electoral college. Suppose this electoral college has 3 individuals. Clear? This individual is representing a constituency. This individual is representing a constituency, and out of 3, any individual who wins 2 constituencies is declared as the winner. So see what happens. The people of this constituency vote, and they vote either in favor of Republicans or Democrats. So if suppose Republican gets 54% of the votes and Democrats get the remaining 46%. Clear? So this particular constituency is won by whom? By the Republicans. Clear? So an individual who is representing this constituency in the electoral college would vote in favor of the Republicans. They will vote in favor of the Republicans. Clear? And suppose in this constituency a Democrat wins. This constituency again a Republican wins. So the individual which is representing this constituency in the electoral college will have to vote for Democrats. इससे फर्क नहीं पड़ता that what is his personal affiliations. It does not matter because the constituency has voted in favor of Republicans, so the individual will vote in favor of Republicans. If the constituency has voted in favor of Democrat, the individual will have to vote in favor of Democrats. And on the basis of this, when any individual who wins more than 50% of the seats in the electoral college is declared as the winner. In electoral college, it is declared as the winner. Their constitution also prescribes what happens if there is a case of tie. What happens if suppose both of the individuals get 284 seats. So what happens in that case? In that case, the lower house, that is the House of Representative that is there, that elects the president. So out of these 465 odd seats that are there, whichever candidate gets more than 460, majority of this seat, that individual becomes the president. So they are not directly elected. They are also indirectly elected. But the mechanism is very similar to direct elections. The mechanism is very similar to direct elections because in India, the members themselves decide whom they are going to vote for. In US, the members have to vote for the candidate which has been voted by the constituency. So if they have been, they get more number of seats, the candidate, that particular individual who is representing them in the electoral college, that individual will have to vote for that candidate in the elections. But in India, it is decided not by us anymore. It is decided by the members of the electoral college. This is the only difference. Otherwise, how we actually elect the president and how they elect, there is no difference. It is very similar. The only difference is we vote in favor of a candidate, we elect him to being a member of Lok Sabha or to being a member of legislative assemblies, and once we elect them, they themselves decide that whom they are going to vote for. But in US, it is decided by the people. They vote in favor of one candidate or a political party, and the member representing them in the electoral college, that individual will have to vote for. They will have to vote for the same candidate. Clear? Their electoral college does not consist of members of House of Representatives, Senate and others. No, that is not the case. They themselves, the electoral college is a very different body. It comes into existence only for electing the president. Once the president is elected, the electoral college is dissolved. Clear? So they are not the same members who get elected to House of Representatives or the Senate or any other body. They are specifically elected for this particular purpose. That is the electoral college. There, the electoral college is technically called as president's electors. Technically उनको इस नाम से बोलते हैं, president's electors. Our electoral college, ठीक है, हम एक ही बार elect करते हैं और बाकी सारी चीजें वही काम चलाते हैं. एक बार हमने elect कर लिया MP or an MLA, now they are doing everything for us. In this is not the case when it comes to US. Clear? Have you understood there? So there, the president that is there, that is elected, the president is elected, he is elected once he is able to secure the majority of the electoral college, which is also the case in India. But the difference is that there, the electoral college that is there, it is a new body who are the representatives of electoral college and who vote in favor of a particular candidate it is dependent upon the people who directly vote in favor of one political party or a candidate. They decide whom the members of the that body, the electoral college that is there, or the individual representing them, whom they are going to vote for. Clear? This is how election of the president is done. Okay? In Russia also you will find that there is elections to the president. वहाँ पर डायरेक्ट इलेक्शंस नाम के लिए होता है, वहाँ इलेक्शंस नहीं होते, पुतिन ही जीतता है. ठीक है. सो इट इज constitutionally speaking, there it is direct elections. Clear? There it is direct elections, but their elections are very, it's not completely free and fair. It's not completely free and fair. And in China that is not the case at all. Okay? So there is no elections in China. People themselves do not decide. In fact, last to last year you must have heard about जो करंट वहाँ के प्रेसिडेंट है, द हेड ऑफ स्टेट दैट इज देयर, जी जिनपिंग, उनको उन्होंने एक स्पेसिफिक नाम दिया है. व्हाट डज दैट मीन? यू नो व्हाट इज दैट पर्टिकुलर स्टेटस? इट मीन्स दैट ही विल रिमेन इन दैट ऑफिस टिल द टाइम ही वांट्स. सो देयर इज नो टेन्योर लाइक इन इंडिया. प्रेसिडेंट इज देयर फॉर 5 years, US president is there for 4 years, Russia president is there for 6 years. Now these time periods, these tenures are decided. But now the status that has been given to the current president of China, so he himself will decide when he is going to retire. So it cannot be. Now there is no scope of election. ठीक है. Previously at least they were किसी न किसी तरीके से अपने में ही कुछ जुगाड़ लगा के करते थे, अब वो भी नहीं करेंगे. So they themselves, they have declared that he is going to be the leader for lifetime, like what happened when Mao. Now that he is only the second individual to get that status. Previously this was given to Mao Zedong, who was actually the individual who led the freedom struggle of China. ठीक है. So they were also struggling against an imperial power. So when the monarchy was removed, etc., so there it was done by an individual called as Mao Zedong, and that individual was also given the same status. He will be the leader for lifetime. He'll be the leader for lifetime, and he himself decided when he's going to retire. Retire नहीं हुए थे, मर गए थे. So he did not retire, he died basically. So similar status has been given to the current president Xi Jinping, and he will himself decide when he is going to retire. Clear? So this is the case. 4 years, 5 years, etc., elections होते हैं. Yes? No. See, the candidate is not a political representative. He can be anyone. And in this case, your political affiliations does not count. Your political affiliations count to that particular extent when you are voting as a member of that constituency. But as an individual, when you are voting in the electoral college, you are going to vote in accordance to what the constituency has decided and not what your political affiliations are. Okay? This is how the president is elected. Next, give a subheading and write impeachment of the president. Impeachment of the president. In brackets write Article 61 of the Constitution. Article 61 of the Constitution. Let's start with first the term impeachment itself. Why is the president impeached and why other authorities are removed? You will find that when it comes to any other constitutional office, whether it is the judge of the Supreme Court, the judge of the High Court, civil servants, all of them are considered to be removed. Comptroller and Auditor General, Election Commission, all these constitutional offices that are there, the members of these constitutional offices, the term that is used for them when it comes to their removal is removal. However, when it comes to the president, the term that is used is impeachment and not removal. The term that is used is impeachment and not removal. So the first question that comes up is, why should we actually use the term impeachment instead of removal? Though you must have heard about, in newspapers, if you are going through the newspapers, in that case, newspapers tend to use this term very loosely. And they also tend to use the term impeachment of the judges. In terms of judges also, they use the term impeachment. But this term is not valid. This term impeachment of judges is not valid. It is actually not technically correct. The reason is, when we compare the term impeachment to removal, what is the difference? The difference is the term impeachment. The president is impeached. Why? Because this is purely a legislative act. Purely a legislative act. Whereas when it comes to the removal of judges of the High Court or Supreme Court, or for that matter any other constitutional bodies, they are not impeached. Why are they not impeached? Because despite the fact that even if we talk about judges, the parliament has the role to play. The Comptroller and Auditor General, Parliament has the role to play. Members of Election Commission, at least the Chief Election Commissioner, not other members, but Chief Election Commissioner, again Parliament has a role to play. But finally they are always removed by the President. Final act that is there, it is by the President. So, though it is partially a legislative act, finally the authority is there with the President. So it becomes an executive act. Who removes the judge of Supreme Court? President. Yes, President does that. President signs the order of removal, or he can sign the order of removal only if there is a certain procedure that has been followed in the Parliament. That is absolutely correct. But the final question is, who removes? It is the President. So it is an executive act and not a legislative act. But when it comes to the President, who removes the President or who impeaches the President? The Parliament. It is a legislative act, not an executive act. It's not that once the Parliament has passed a resolution to impeach the President, it goes to the Vice President and the Vice President signs. No. Once the Parliament has passed a resolution to impeach the President, as soon as that resolution is passed, the President stands impeached. The President stands impeached. There is no need for further approval from any individual. So it is purely a legislative act. And that is the reason why we use the term impeachment and not the term removal. On the other hand, when it comes to the judges, we tend to use the term removal. Similarly, when you take the case of US, in US also you will find that the term impeachment is used with President. Abhi chal raha hai, you must have heard about it. So there also the term impeachment is used, but there for the judges of the court, Supreme Court, etc., their term impeachment is used. Judges, the judges that are there in the federal court, or for that matter the Supreme Courts, because every state has a Supreme Court there. Every state has a Supreme Court and there is a federal court at the federal level. But there is Supreme Court is present in every state there. So when their judges are being removed, they are being impeached. Why they are being impeached? Because they are being impeached by the concerned legislature. They are being impeached by the concerned legislature. Even when it comes to the impeachment of the federal court there, judges of federal court there, federal court judges are also being impeached there. Why? Because there the role that is played by the legislature is great. The Senate approves impeachment, and the authority of the Senate here is absolute. It cannot be, it cannot be revoked or something like that. It cannot be done. So there the term impeachment is still relevant when it comes to judges. But in our case, that is not the so. That is not the case. Because if it would have been, till now you must never have heard about any particular judge being impeached in India. Never it has happened that there is a judge who has been impeached in India. But there was a resolution that was passed by both the houses of the parliament. There was a judge, I think Judge Ramaswamy or something his name was. He was, to impeach him, to remove him, the legislature passed a resolution. But the legislature, despite the fact that legislature passed the resolution, because it was till that particular time it was not approved by the president, he was not, he was not removed. As soon as the legislature passed, he resigned. No, he resigned. But legislature passing the resolution did not mean he was automatically removed. It had to go to the president. The president had to sign the order of removal. So until unless that process is completed, you cannot remove a judge. So ultimately, it lies with that of the president. And that is because it is an executive act. It is called as removal. When it is a legislative act, it is called as impeachment. Clear? The term impeachment is clear. Why we are saying impeachment, not removal. So this is the manner. Now, what does Article 61 of the Constitution say? Article 61 of the Constitution says an individual, that is the president, can be removed on what grounds? The grounds that have been mentioned in the Constitution under Article 61 is the ground of violation of the Constitution. If any individual violates the Constitution of India, that individual, if he is the president, he is likely to be impeached. However, what amounts to the violation of the Constitution has not been mentioned in the Constitution. What is violation? It is not mentioned in the Constitution. This violation is politically determined. This violation, whether an individual has violated the Constitution, whether the president has violated the Constitution or not, it is politically determined. When we say it is politically determined, what do we mean? It is determined by the parliament. It is determined by the parliament. And to impeach the president, a resolution needs to be introduced. In either house of the parliament. A resolution needs to be introduced in either house of the parliament. So it can be introduced in the Lok Sabha, it can be introduced in the Rajya Sabha. For its introduction, the resolution requires the support of not less than 1/4 members, 1/4 of the total members or the total strength. So for its introduction itself, it requires at least 1/4 of the total members or the total strength of the house that is there. If they support a resolution to impeach the president, only then that particular resolution can be introduced. If not, it cannot be introduced. Once it is introduced, that is the resolution that is introduced, a 14-day notice is served to the president. A 14-day notice is served to the president, and the resolution or passage of the resolution can be taken up only at the expiry of. To be introduced requires the support of 1/4 of the total strength of the house, and once it receives the support of 1/4 of the total strength of the house, a resolution, a 14-day notice is served to the president, and any procedure to pass the resolution can be taken up only after the expiry of 14 days, not before that, only after the expiry. Only after the expiry of the 14-day notice. After the 14-day notice has passed, then the house takes up that resolution to vote, and it requires the support of not less than 2/3 of the total strength of the house. It requires the support of not less than 2/3 members of the total strength of the house. Clear? The key point here being 2/3 of the total strength, not present and voting. I said 2/3 of the total strength of the house. Clear? After it is passed from the first house, it goes to the second house. It goes to the second house, and the second house acts as an investigating house. The second house acts as an investigating house. That means it is in the second house that the charges of violation is investigated, not in the first house. The first house does what? Simply serves a 14-day notice once it is introduced, and after the 14-day notice expires, they vote, and if it gets the said majority, it is said to have been passed by the first house. Now it goes to the second house. The second house acts as an investigating house. Now when I say the second house acts as an investigating house, what does that mean? Either the house can itself investigate, either the house can itself investigate, or cause an investigation. Or it can cause an investigation, which means either the house itself investigates or authorizes some other body to investigate the charge. It can even authorize some other body to investigate the charge. Clear? The president has the right. The president has the right to defense. To defense in the second house. That is the investigating house. The president has the right to defense in the investigating house, the second house. Why? Why have we given this right to the president? If we do not give this right to the president, so what will be the consequence of it? What will be the consequence of it? Legal terms में सोचो. Violation of Article 14. Is it Article 14? Why are you saying it is violation of Article 14? Yes? It is violation of Article 21 and 14. Why? Because remember, we did talk about principle of natural justice. And what was the first principle? Punished unheard. Audi alteram partem. मैंने बोला था ना, आप मुझे देख रहे थे कि सर स्पेलिंग क्या है. हाँ, याद करो. Audi alteram partem, which means what? It means no one should be punished unheard. So how can we punish the highest dignitary of this country unheard? Clear? So he is given the right to defense. When you say Article 14, it is absolutely correct. Why? Because remember, Bhojnath Ganguly case, Inland Waterways versus Bhojnath Ganguly. In that case, the Supreme Court declared what? That Article 9, the principle of natural justice is inherent even in Article 14 of the Constitution. So what you said is absolutely correct, but there are two articles, not just Article 14, it will also be a violation of Article 21. Why? Because principle of natural justice is inherent in Article 21. ठीक है, अभी भी बताने की जरूरत नहीं पड़नी चाहिए मुझे. You should have, as automatically this should have come, that it is a violation of natural justice. So the president has been given the right to defense here. The president can defend himself. However, if the second house also passes, if the second house also passes, the second house also passes the resolution by the same majority, 2/3 of the total strength of the house, the president stands impeached. The president stands impeached as soon as the resolution is passed. ऐसा नहीं कि उनको मौका दे रहे कि आप 10 दिन का टाइम है, घर खाली कर दो, बहुत बड़ा घर है. नहीं, as soon as the resolution is passed in the second house, now the president is impeached, which means he is no more the president of the country. He is impeached. Clear? So 2/3 of the majority of the total strength of the house, not just now present and voting, it is the total strength of the house. So this is why we say that this violation of the constitution is politically determined. Who is determining this? The parliament. Parliament is determined, not in legal sense. It is not forced to decide it in legal sense. If it is itself investigating, they may not come up with a legal sense of whether he has violated the constitution or not. It is politically determined by the house. It is politically determined by the house. It does not say that if the president is to be impeached, yes, the house will come up with a committee. Committee will comprise of Supreme Court judge, High Court judges, and they will determine whether violation has happened or not. No, it does not mandate for any such procedure. What does it say? It just says that the second house will investigate the charge, and if the second house on the investigation of such charges, even if it passes the resolution, even if it passes the resolution by the 2/3 majority of the total strength, then the impeachment stands and the president is impeached. Even if the president proves that he himself has not violated the constitution, it does not have any effect. He has the right to defend himself. But if he, is it mentioned in the constitution that if he will prove that he has not violated the constitution? No. Even if he does that, but still the second house passes the resolution by 2/3 majority of the total strength of the house, in that case it will be impeached. He will be impeached from the house. And because the second house is acting as a investigating house, we say that impeachment of the president, in impeachment of the president, the second house is following a quasi-judicial procedure. It is following a quasi-judicial. It is quasi-judicial. The nature is what? In this case specifically, it is of quasi-judicial nature. It is quasi-judicial in nature. Clear? Clear? So this is how the president is impeached. This is how the president is impeached. So just once more so that you are absolutely clear about the process. It is impeachment of the president is done under Article 61 of the Constitution. 61 of the Constitution lays the grounds for impeachment, and the ground for impeachment is violation of the Constitution. But this, what is violation of the Constitution, has not been defined by the Constitution. In India, violation of the Constitution is politically determined. It is politically determined. How is it politically determined? It is politically determined because a resolution to impeach the president is introduced, it can be introduced in either of the houses of the parliament. For its introduction, it requires at least the support of 1/4 of the total strength of the house. If it gets the required support, the house does what? It sends a 14-day notice to the president, and any step that the house has to take, it will take up only after the expiry of that 14 days. Only after the expiry of that 14 days. Why this 14 days? Again, if you look at it, why this 14 days? Why is there a need to give the president 14 days? Violation of natural justice. What is the next provision? Every authority will act bona fide. Bona fide with good intentions. Good intention means what? You will at least give the individual the right to defend himself. So if he does not have the right to defend himself, can it be considered again as an appropriate procedure? No, it will be a violation. So you will give him 14 days so that he prepares himself with his defense, etc., etc. And after 14 days, you pass a resolution which requires the strength of the majority of 2/3 of the total strength of the house. Once the first house passes it, it goes to the second house. In the second house acts as an investigating house. It may investigate the charges by itself, or it may cause for an investigation. Clear? It may cause for an investigation. In the second house, the president has the right. The president has the right to do what? To defend itself. The president has the right to defend in the second house. After the procedure, if the second house also passes the resolution by the same majority, 2/3 majority, in that case the president stands impeached. Clear? So that is the reason why we say the impeachment of the president is politically determined. Understood this idea? Understood this idea? Now give a subheading, right? Veto powers of the president. Veto powers of the president. A way to discuss the powers and duties of the president is कि मैं आपको ये बताऊं what are the executive powers, what are the legislative powers, what are the judicial powers, what are the military powers, what are the diplomatic powers, etc., etc. But that is very factual in nature, so we are not going to discuss that. What I want you to do is, you are referring to Lakshmikant, you need to add this as a part of either, if you are as a part of your discussion, our discussion, you have to add what are the powers that the president enjoys. I am not going to discuss all of it in the class. Just add here what are the executive powers, what are the legislative powers, what are the judicial powers. Just add it here. I am going to discuss, in terms of powers, I am going to discuss 2 or 3 ideas. First of all, I am going to discuss what are veto powers. Then I am going to discuss something called as discretionary powers, and then I am going to discuss something called as ordinance making powers. Clear? These are the 3 ideas which are technical, which needs certain understanding. There have been certain cases here, so I am going to discuss these ideas. Rest of it, what is the power and duties that the president has, you are going to do that. In certain cases, as a part of supplementary discussion, it will come up. Some of these powers will come up. Like when it comes to appointment of judges, you are going to read it, I am going to discuss it there also. So as a part of supplementary discussion, it will come up. So because it comes up as a part of supplementary discussion, I am not going to overlap that idea, and later on you are going to come to that. So I will be discussing only those ideas which are immensely important and which are likely to be asked. So let's start with the veto powers of the president. Veto powers of the president. See, what are veto powers? Basically, there are, going back to our discussion earlier on, in fact, in the very first class, we did discuss something called as separation of powers. When we were discussing separation of powers, we talked about something called as checks and balances. That means we have three organs of the state: the legislature, executive, and the judiciary. This division of powers of the state into three, executive, legislature, and judiciary, this is what is called as separation of powers. What was the reason? Montesquieu said, etc., etc. We have already discussed that. However, when it was adopted for the first time by the first written constitution of the world, that is the Constitution of US modified separation of powers as advocated by Montesquieu and adopted along with separation of powers the principle of checks and balances. Principle of checks and balances. In principle of checks and balances, we had discussed that every of these three organs will have some provisions in which they will check the powers of the other organ to create an equilibrium or balance of powers. No authority will override the powers of others, ensuring a balance of powers, no presence of arbitrary power for any authority. So what is veto power? Veto power is the power of the president to do what? The power of the president to temporarily or permanently stop a legislation. It is power of the president to temporarily or to temporarily or permanently stop a legislation. To stop a legislation. Temporarily or permanently stop a legislation. Which means, if you compare this idea to what we had discussed in checks and balances, veto power is like a check on the power of the legislature. It is like a check on the power of the legislature. Clear? So veto power is a mechanism in India. Veto power of the president is a mechanism through which this checks and balances comes into effect. This checks and balances is coming into effect through this particular mechanism. Clear? Absolutely clear? Now, when we talk about veto power of the president works in this manner. Whenever a bill is passed, by the parliament, it goes to the president for presidential assent. As soon as the president gives his assent to the bill becomes a law. The bill becomes a law. The bill becomes an act of the parliament. We say the bill becomes an act of the parliament. When a bill goes to the president has these choices. First, give his assent to the bill and sign the bill. Clear? Second, to declare to declare that he withholds his assent. To declare that he withholds his assent. Now, when the president declares that he withholds his assent, what does that mean? He says, nahi sign karunga. He says, I will not sign this particular bill. When he declares that he is withholding his assent, it means what? It means he has exercised his absolute veto. He has exercised his absolute veto. What is the consequence of this? The consequence of this is bill dies. It cannot be revived. The bill dies, which means the bill cannot be revived. Khatam ho gaya wo bill. Despite the fact that the parliament has passed the bill, but the bill is dead. No more it can be revived. And this can be exercised by the president. That is, absolute veto can be exercised by the president only if it is an ordinary bill or a financial bill. In fact, any veto can be exercised only if it is an ordinary bill or a financial bill, which means if it is a money bill or if it is a constitutional amendment bill, the president constitutionally does not enjoy the right to exercise veto. He cannot. Only when it is an ordinary bill or when it is a financial bill. Only in these two cases. Next, absolute veto can be exercised by the president only when the Council of Ministers have advised the president to exercise absolute veto. The absolute veto can be exercised only in this ground when the Council of Ministers have advised the president to exercise his veto powers, absolute veto powers. Otherwise, he cannot. Otherwise, he cannot. Which means it is dependent upon what? It is dependent upon the aid and advice of the Council of Ministers. The aid and advice of the Council of Ministers. Third, he returns the bill for reconsideration of the House. He returns the bill for reconsideration of the House. Now, when he does this, when he sends the bill for the reconsideration, it is called as suspensive veto. It is called as suspensive veto. Clear? Again, suspensive veto can be exercised only if there is an ordinary bill or a financial bill. In case of constitutional amendment bill, in case of money bill, they cannot exercise. The president does not have the power to exercise veto. Suspensive veto, what is the consequence of suspensive veto? The bill goes back to the parliament. And if the parliament passes the bill again, the president has no choice but to sign the bill, to give his assent to the bill. But suspensive veto means once the parliament would consider or reconsider the bill. It will lead to what? Reconsideration of the bill. If the parliament passes the bill again, the president has to give, the president shall, sorry, use the term shall give his assent to the bill. The president shall give his assent to the bill. Suspensive veto is exercised by the president in his discretion. Suspensive veto is exercised by the president in his discretion. And the last time it was exercised in 2006 when APJ Abdul Kalam, he was the president, and he used suspensive veto in case of Office of Profit Amendment Bill. Office of Profit Amendment Bill. In 2006, he used his suspensive veto. He openly spoke against the bill. Despite he openly discussed his views were against the bill, the parliament passed the bill. It was very likely that the president, it was considered that he is going to use his veto powers, and he used his suspensive veto, wherein he returned the bill for the reconsideration of the House. However, the parliament again passed the bill. It went to the president and the president signed the bill. What is the fourth option? The fourth option is he does not take any action. That means the president, I am rubbing this off, the president allows the bill to lie on his desk. On his desk, which means he takes none of these three. Neither he gives his assent, nor he declares that he is withholding assent, nor he is doing what? He is returning the bill. He lets the bill lie on his desk. What is the consequence of it? See, the bill is alive. The bill is alive. The bill is alive, but it is not a law, which means it is not enforceable because the president has not given his assent. So it will remain like that. Unlike that of absolute veto, wherein he declares that he is withholding his assent, and once he declares he is withholding his assent, what is the consequence? The bill dies. Unlike that, in this case, the bill remains alive. The bill remains alive till the Lok Sabha is not dissolved. The bill remains alive. The bill continues, but it is in his desk, on his desk. He does not take any action. This is called as pocket veto. This is called as pocket veto. And again, like that of other vetoes, it is also exercised only in case of ordinary bill and in case of financial bill. It is exercised in discretion. That is, without the aid and advice of the Council of Ministers. without the aid and advice of the Council of Ministers. Clear? This bill, this has in fact also been used, pocket veto has also been used. In fact, multiple times it has been used. Rajendra Prasad used it when he was actually, there was a bill passed called as Pepsi appropriation bill in 1956. He used his pocket veto. Okay, he used his pocket veto. Secondly, again, there was Indian Postal Amendment Bill 1986. Gyani Zail Singh used his pocket veto against the Rajiv Gandhi government, which led to deterioration of relationship between Zail Singh and Rajiv Gandhi to an extent wherein they were not at talking terms. In fact, to an extent wherein once for the only time wherein the government thought of impeaching the president was when Rajiv Gandhi thought of impeaching Gyani Zail Singh. And because Bofor's case came up, so Zail Singh was thinking of removing Rajiv Gandhi. So he was contemplating ki kya in case of corruption, can the president remove the prime minister? So he was taking legal advice, and the prime minister was thinking of impeaching the president. The only case when he actually, once the government actually thought of it. Clear? So that happened, and then there was something called as Salaries and Allowances of MPs Amendment Bill 1991, and R. Venkatraman, he used his pocket veto in that particular case. They wanted to increase salaries of MPs and MPs. Now he said, I will use my pocket veto. So he did not allow that. So the bill was alive till the time it remained on his desk. The bill was alive, but he did not give his assent. Neither he declared that he is withholding assent, and neither he returned the bill for reconsideration. In fact, when Abdul Kalam used his Office of Profit Amendment Bill, it was contemplated that he is going to use pocket veto because he had openly talked about this bill. So it was very likely that he was going to use his pocket veto, but he did not use his pocket veto. He used, in fact, he used his suspensive veto. So this is something that is that is very rare in terms of veto powers that are there. It does not happen. It generally does not happen, and there have been in the last 70 odd years, there have been only 3 to 4 cases in which veto powers has been used by the president. Clear? It is very unlike president to do this. Veto powers, pocket veto is used in the discretion of the president, and there is no counter to it. If the president wants, he will pocket a particular bill and no one can do anything about it. No one can do anything about this because it is a constitutional power that he has to do what? To basically operationalize the idea of checks and balances. So he has this particular power, but the bill also does not die. So it's not that again the parliament is going to enact a new bill and send it. That also cannot happen, because that can happen when he has declared that he is withholding his assent. So that particular bill dies, but it does not restrict power of the parliament to come up with another bill for the same thing. That is not restricted. But in this case, because the bill is alive, the bill still remains alive, so the parliament does not do it. How can the parliament enact the same law twice? That is not something that happens. So pocket veto is one of those powers which the president has in terms of effective power, that it has to either permanently stop a legislation. That is very effective in terms of permanently or almost permanently stopping a legislation. In this case, because the bill is alive, suppose the president after 5 years, completion of 5 years, he goes out of office and a new president comes, he may sign the bill. He may sign the bill. So he comes to office, the Council of Ministers asks that maine aapko elect kiya na, please sign the bill. So he will sign the bill. It can happen. Clear? So this is what is the veto powers. See, why is it that in India No, such powers that are exercised by the president are rare. Because in India, president is only a ceremonial head and the real power lies with the Council of Ministers. Because the Council of Ministers are also the part of legislature. No, they are the part of legislature. So in a parliamentary form of system, what happens? Parliamentary system, the executive belongs to the legislature. So in terms of deadlock between the executive and the legislature, it rarely happens. In a presidential system, this happens almost every month. In a presidential system like that of US, this power wherein the executive exercises veto powers, it is something that happens very frequently. Deadlock is very frequent when it comes to a presidential system. Why? Because there is absolute separation there. So the executive does not belong to the legislature. So it may so happen that the executive belongs to, suppose, a Republican party, and the legislature, House of Representatives and Senate, both are dominated by the Democrats. So they will pass a legislation. Because the president belongs to some other political party, he will veto it. He will veto it. Sometimes this also happens. The president enacts the budget, sends to the legislature, legislature says nahi pass karunga. This happens. It leads to a lot of deadlock when it comes to a presidential system. Why did India adopt for a parliamentary system? Because the kind of diversity that is in existence, it was very likely that this deadlock was more frequent in India than in any other country. And that is the reason why parliamentary system becomes more suited to India than presidential system. In US, suspensive veto that is there is a different version of suspensive veto that is present. That is called as qualified veto. What happens is, once the legislature passes a bill, it goes to the president uses his qualified veto, it is returned back to the legislature. Now the legislature has to pass it with a higher majority, not similar majority, with a higher majority. If it is passed by a higher majority, the president has to sign it. But it is very difficult. Why? Because in US there is only a two-party system, which means if there are members who have voted against it because they belong to a certain political ideology, it's very likely that they change their stance on the bill. So their qualified veto becomes very effective. In India, suspensive veto is not that effective because the parliament can override the decision of the president. But their qualified veto is very effective. Clear? So the version in which the suspensive veto in US is called as qualified veto, but it is a bit modified format of suspensive veto, wherein once the president returns the bill back, then it has to be passed by a higher majority in both the houses. Clear? This is the veto powers of the president. This is where I stop my discussion today. When we meet next, we continue with our discussion on the president. Next class, we'll dedicate it to the president, and we are very likely to complete our discussion on the president. Thank you.